Travellers Insurance Company Limited and XYZ.
Now, as I understand it, the court is invited to make an anonymity order in this case, and the terms of that order, I think, have been agreed between the parties. Is that right? Right, very well. Well, in that case, the court will order that no one shall publish or reveal the name or address of the respondents who are the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the respondents or of any member of their families in connection with these proceedings. The reason for that order is that although the issue in this appeal is to do with the costs of proceedings, the underlying proceedings themselves are to do with the breast implants that were defective, which were supplied by PIP some years ago, and the persons whose anonymity is being protected are women who received these implants.
Lords, my lady, I appear together with Mr. Lynch for the appellants, Mr. Preston and Mr. Pilgersdorfer appear for the respondents. The essential starting point for this appeal must be the legal basis on which travellers came to be paying defence costs referable not just to the insured claims against Transform, but also the uninsured claims, and that the provisions to be found in the policy, that's in the core volume bundle, it's page 364. Appendix 1. The insuring clauses on the top of 364 on the left, company will indemnify the insured.
Appendix Part 1.
Yes.
Do you have flags?
Page 36, tab 8. Tab 8 of the core one, the core volume. Core volume.
Yes.
Page 364. Company will indemnify the insured, subject to the limits of indemnity in respect of all sums which the insured shall become legally liable to pay as compensation for and arising out of accidental injury or damage occurring during the period of insurance. As with typical public and products liability insurance, it only responds to injury or damage occurring during the period of insurance, which was of relevance to the scope of cover in this case. Under paragraph 2, cover for claimants' costs and expenses only covers claimants' costs and expenses in connection with the indemnity provided under clause 1 of the cover. And then clause 3, the defence costs and expenses, company will in addition indemnify the insured in respect of all costs of legal representation reasonably incurred with the company's written consent at any Roman II proceedings in any court, and then other costs and expenses reasonably incurred with the company's written consent in relation to any matter, then the important proviso, which may be the subject of indemnity under clause 1 of the cover. There's a rather arid debate about the extent to which costs fell under, defence costs fell under A2 and B, or just A2. It doesn't probably matter, but our submission was that one way or another, Travellers was contractually obliged to pay the defence costs in respect of insured claims, and also was contractually liable to indemnify Transform for the claimant's costs on the insured claims, but not otherwise. The effect of the authorities, they're dealt with in our case, and I hope there's no need to go to them because I think they're common ground. The effect of the authorities is that the limitation on the defence costs indemnity to insured claims doesn't mean that Travellers could have apportioned the defence costs between insured and uninsured claims insofar as those defence costs related to issues which were common to both claims. The classic starting point case for that is the New Zealand Forest Products case. Just for your reference, is at tab 14 of the first volume. That was a case where the action in America was against a number of defendants, only one of whom was insured. But the insurers were held liable to pay all of the common defence costs because they were liable to indemnify that insured and were not entitled to apportion the defence costs. So that was the starting point. It was applied by Mr. Justice Coleman in the Thornton-Springer case, and it was also applied by this court in IEG and Zurich, holding that Zurich, even though on risk for only 6 out of 27 years of cover, were responsible for indemnifying the defence costs for the entirety of the victim's claim against the insured by reference to those 6 years of insurance.
Is that in our bundle?
Yes, my lord, that's at tab 11 of A1. The Thornton-Springer case is at 17. The relevant passages in IG and Zurich are paragraphs 36 to 38, but as I said, I hope this is common ground as a matter of law and therefore uncontroversial. The other important element for this preliminary stage is the GLO itself, which is in Appendix 2 at page 449. That's tab 7. Group litigation order, and the relevant passages are firstly page 453, paragraph 5 in the middle of the page, where it identifies the group litigation order issues and identifies the common or related issues of fact or law. Then at page 454 over the page, there is the costs sharing order at paragraph 12 towards the foot of the page. At 12.1.4, the common costs incurred in any quarter by the claimants are to be divided by the number of claimants pursuing their claims on the first day of the quarter. That's where this issue arose, that Travellers was funding the defence of the common issues by reference to the insured claims, but was not liable to provide an indemnity in respect of the claimant's costs of the uninsured claims, which they were obliged to pay pursuant to that provision. And then finally at this stage, the minute of order at page 461, tab 8.
Can I just mention that some of us, if we're using hard copies, don't have the electronic numbers printed on the hard copy. So just so you're aware of that. So, for example, tab 8, it begins on a page which is numbered 91.
Can I use those numbers? I have those numbers on my bundle.
You'll also need, for those who prefer to do it electronically, they'll need the E numbers.
I use those numbers. I was trying to stick to the usual direction that that reference should only be to the electronic numbers, but I'll do the originals. Fortunately, I had my original bundle and renumbered it. So page 91, you'll then see the common issues in certain actions. There were adjustments to which actions were sample cases, but that doesn't matter. You'll see that common issues were to be determined in the sample cases, And over the page, you'll see 2.1 and 2.2. There are common issues about whether the implants were supplied in breach of the implied term and what remedies should be afforded under the statute. So the starting point is that necessarily, as this was group litigation, but in any event, there were common issues in the litigation which fell to be determined in sample cases, and travellers had no contractual option but to fund the defence of those common issues, even though that defence benefited uninsured as well as insured claims, and the uninsured claims, I should clarify, fell into two categories, as you'll probably have seen: those who had suffered no injuries at all, the worried well, and those who had suffered injury, but the injury had not occurred during travellers' period of insurance. And those are essentially the respondents to this appeal who seek to recover their costs for which travellers was not contractually liable to provide an indemnity through the Section 51 route. Now, there are three essential elements to the respondent's case in support of the Section 51 order. They say, firstly, the discretion under Section 51 is a very broad one. The courts below were entitled to disregard what we refer to as the Chapman line of authority on liability insurance, and to make an order against travellers. Secondly, they seek to resurrect the judge's starting point, which was rejected by the Court of Appeal, that travellers had no legitimate interest at all in the uninsured claims and should attract Section 51 liability by virtue of having funded and exercised some control and influence over the uninsured claims. And I'll refer to that as the nil involvement point, because that seems to be what the respondent's case amounts to. Their third point is the principle of reciprocity, which found favour with the Court of Appeal. In the limited time available to me, I'll seek to address the main submissions made by the respondents in their case, although of course the substance of our submissions remains as set out in our case. But by way of preliminary observation, given that this is an appeal from the decision of the Court of Appeal, it does seem rather odd that in the respondent's case they have put the judge's rejected reasoning ahead of that of the Court of Appeal, perhaps betraying a recognition that the Court of Appeal's judgment is, as we've sought to explain, difficult to justify. But in any event, the logical order must be to consider reciprocity before the nil involvement point, because I accept that it's only if I can persuade you that the Court of Appeal's reasoning can't be justified that we get on to seeing whether there is some other basis on which it could be justified, the most obvious being the way the judge approached it. And so I'll address them in that order: reciprocity first and then nil involvement. But that doesn't, of course, affect the need at the outset to consider the critical first topic, which is the principles on which the discretion should be exercised. And that's what I now turn to: the scope of and principles underlying this, the exercise of this discretion. Now, the respondents say that the court should focus on the underlying principle. What they fail to do in our submission, though, in their case, is actually to identify what the supposed underlying principle actually is. If it's simply saying that the court can do whatever it thinks is just, well, that, we say, can't be right. It simply invites a sort of palm tree justice approach, which encompasses financial engineering so as to extract money from a deep pocket. The fact that the respondents can't be contemplating that is demonstrated by the fact they accept that the Chapman principles will ordinarily apply in liability insurance cases. So they don't in any way seek to attack or undermine those principles. And that is of significance because, of course, if one goes to the next level of particularity as to the criteria for the discretion, one then gets to the exceptional language, something outside the norm. And the fact that the respondents accept, as they have to, that the Chapman line would ordinarily apply to liability insurance cases demonstrates that they must be accepting, or must accept if they don't, that what is significant in the exceptional test is the non-party's conduct or status in relation to the litigation. There must be something exceptional or outside the norm about the non-party's conduct or status. And that makes perfect sense, because this is a jurisdiction which is being exercised against a non-party, someone who's not been involved in the litigation. And so it's perfectly understandable that the focus should be on what that non-party has done or their status in relation to the litigation, which makes it just to impose an order against them, even though they were not a party to the litigation. And that's why when we come to look at the authorities, we'll see that they do focus on whether the non-party has become the real party to the litigation, the defendant in all but name. And that's why the Chapman line of authorities focuses on whether the liability insurer has overstepped the mark so as to become the real party, with the insured just being a nominal defendant.
The Chapman line of cases goes wider than that, though, doesn't it? It's not limited to that situation.
That's what it actually addresses. It addresses what they have done in that regard, whether they have controlled it, the litigation, for their self-interest.
Yes, I mean, the problem is that formulation, whether you controlled or directed the litigation in your own interest, is unbelievably broad. It would encompass all sorts of cases where people had, for example, acted as agent for a company in circumstances where they were also substantial shareholders. Imagine vast categories of case in which that principle, if it is a principle, would apply. So some limitation has got to be found. I don't read Chapman as limiting it to what one might call intermeddlers, or people where cases where the third party is substantially the litigant.
Well, the Chapman line is, of course, focusing entirely on liability insurance. It's not dealing with other categories of...
No, I know, but the test which they formulate is capable of application to so many other situations that one is bound to ask oneself whether it's not too broad.
Well, it may be that it is, that one has to be careful about translating precisely what is said to other scenarios, or indeed to liability insurance. But the nub of our submission is that when one's looking at the exercise of the discretion, one has to be looking to something that the non-party has done, and their status in relation to the litigation and how they've acted in relation to the litigation, which makes it just to make an order against them, even though they weren't a party. And the essential test, which is perhaps the obvious one that would fall within the ambit of Section 51, would be where the actual defendant is merely a nominal defendant and is merely a vehicle for the pursuit of the non-party's own interests.
So, for example, if the insurer brings a subrogated claim against a third party, having, as he must, paid off the insured therefore has no interest other than a nominal interest as the necessary plaintiff.
And that was the situation in Chapman. And that's why we say in our submissions where the Court of Appeal misunderstood the reciprocity point. The reciprocity that the court was talking about in that case was the fact that the plaintiff, I think in those days, in that case, was an insurer pursuing a subrogated claim. And so the reciprocity that they were talking about was the fact that if the defendant had won, the insurer on the other side was also a nominal defendant and would also have been liable to a Section 51 costs order. And so that you want, precisely, my lord, that is why one gets that same situation.
But Chapman suggests that if you conduct the defence unsuccessfully of an insolvent insured, that may give rise to a liability to pay the costs, even beyond the limit of the insurance. Now, are we looking at whether the insured has a legal interest or whether he has a commercial interest? I mean, an insolvent insured has a legal interest in not being found liable. There's then a separate question whether he has the kind of interest that one would care about. If one's bust, one may not care what happens. But is that kind of interest relevant, what you submit?
One needs to be careful when one uses the phrase insolvent insured, because there may well be situations, and this may be one, where if the defendant loses, they will be insolvent, or the reserve for the prospect of losing and having to pay costs for uninsured elements would render them insolvent. But a successful outcome, we say, even if it gives them a chance to carry on in business, even if you can say, well, they're a bit still financially uncertain, but they've got a chance of carrying on in business, that we would submit would be of itself a sufficient interest. And there may be cases where an insured is fully covered, and this is particularly in the professional indemnity field. So they have no financial interest in the case at all, but nonetheless, they have a reputational interest. They don't want to be held liable for negligence, even though the financial consequences to them are nil.
But I was just thinking, for example, of a consultant gynecologist. A claim against him, if he were uninsured, would no doubt render him insolvent, if it were a severely handicapped child, for example. But even though he's fully insured, he has a very substantial interest in the outcome of the proceedings. And
there are two interests to be identified there. The first is reputational. Even if he's retired, he would not want his name sullied by a finding of negligence. But there is also the financial one of not being rendered insolvent and having assets taken. But even if he had no assets, it's still the stigma of a bankruptcy.
But I mean, does stigma matter? I mean, one possible view is the only kind of interest that is relevant is a legal interest in the outcome. Everybody has a legal interest in not being held to be negligent or indebted or what have you. There are two separate questions. One is, do you have an interest? And the other is, do you care whether you've had an interest or not? I find it difficult to see on what basis whether you care about your interests because of extraneous reasons like having no assets. I can't see how that can make the slightest difference to the analysis. The possession of a legal interest, such as every defendant has got, whether insured or not, whether solvent or not, whether assetless or not, is a sufficient interest, but I can't see why anything else should be.
Well, don't want to push it open doors, but the way that the courts have approached it is to ask whether the defendant is really just a nominal defendant. Now, obviously, as a defendant, there must be a legal interest, otherwise they wouldn't be a defendant. There must be a legal claim against them to give that party a legal interest.
The fact that the defendant doesn't care whether he's liable or not doesn't make him a nominal defendant.
Well, let's take an example of a company that has been struck off the register and is restored to the register in order to be sued so that its insurance can be accessed. It would be difficult to say that defendant's legal interest as a legal entity meant that Section 51 wasn't applicable. I would accept that in those circumstances, the real party to the litigation is the insurer, because the company had ceased to exist. It only was brought back into existence for the simple purpose of being a vehicle of accessing the insurance. Things have moved on, of course.
That would normally be via the third parties legislation.
Yes, but you would have needed to have got a judgment against, under the old regime, you would have needed to have got a judgment against the company. And the insurer might have wanted to take a pot at defending that. They might have had coverage defences, but also defences on the merits, and then decided that they were going to defend the company on the merits first before they turned to their coverage defences. And so they might then defend the restored company, which would then have no interest other than the bare legal interest as the defendant. But where I do respectfully accept what my Lord is putting to me is that the courts should not be too assiduous in trying to identify some substantive interest on the part of the defendant. It's only in the extreme cases where there really is no interest at all other than the bare legal interest in the outcome, which renders the insurer the real defendant in a liability insurance case.
Your example is of a company that could stave off insolvency by a successful defence is one, but another is where the company is already in an insolvency process, but where the outcome of litigation brought back. Assets that are available are distributed among the unsecured creditors.
Still may have an interest through the creditors, and as in this case, behind the scenes, there may also be issues as to whether someone wants to come in and rescue the company, take over. If it has a brand name but is insolvent, it may be an attractive commercial proposition free of these liabilities. With these liabilities, the price is going to be too high to resurrect it. So there are all sorts of shades of grey about this level of interest, and it's only really in the stark cases that one can treat an insurer as the real defendant. But of course, it is possible for the insured to have an interest, but actually the insurer to treat the litigation as if the insured didn't exist. So when they run it as if they are the real defendant. And that may be more what the Chapman line is getting at, if the insurers, even though the insured may have an interest, treat the litigation as effectively their vehicle and allow their interests to predominate over the insured's to the exclusion of the insured. Now, since the standard of conduct of insurers doesn't start from the Section 51 line of cases. One might be tempted to think that the Section 51 cases are setting the standards of how insurers should behave. But in fact, it goes back to Groom and Crocker, which is a case in the 1930s, and that was under the infamous knock-for-knock regime, where the insurers, under a knock-for-knock arrangement, prevailed on the solicitors to admit liability for their insured, and the insured sued the solicitors for professional negligence for making the admission when he had a good defence to the claim. And when one goes to the authorities in the Chapman line, one then finds the decision in Cormac, and this is the Authorities Bundle 1, tab 5, and if I can perhaps I invite you to look at this.
Do you have an electronic page number?
The electronic page, it starts at 1071. And the relevant passage in the judgment starts at 1077 under the heading Exceptionality in the bottom right, and then it reviews what had been said in Chapman, and about a third of the way down the first column on 1078, the court, Lord Justice Auld says, it's plain from those remarks in his ensuing consideration of the insurer's arguments on those features that the distinguishing circumstance of the case, which with all others rendered it exceptional, was the insurer's overriding self-interest in the conduct of the proceedings, converting it for all practical purposes into the defendant. And at the bottom of the page, of that column, you can see what the deputy judge had said. Deputy judge here adopted the same approach, taking as the principal question for decision and mark of exceptionality whether, having regard to the contractual limit of indemnity, the excess's conduct of the action was sufficiently self-motivated to the exclusion of the defendant's interest to subject it as a non-party to an order for costs.
Is the point that's being made there that there's got to be something more than the fact that it's in the insurer's interest to defeat the claim because it's insured?
Exactly, my lord, yes. That, because, of course, the insurers share that interest with the insured and will do so in all liability insurance cases. They will always share that interest. And what this is posing, what the Chapman line is posing is, did the insurer, notwithstanding the insured's interest in the case, actually conduct itself as if the insured didn't matter? As if all that mattered was their own interests, and it doesn't matter what the consequences of that may be for the insured.
That could only arise if some question arose on which the interests of the insured and the insurer were different.
And at the bottom of the quotation on that column, he said, I consider the judge in so expressing himself, deputy judge applied the correct test on the material before him. He was entitled to exercise his discretion in the way he did. And then he sets out what the norm is, and this is important. Of course, the norm is that the insurer has control of the litigation and may act predominantly in his own interest in doing so. So that's a given in liability insurance. In most cases of professional indemnity and product liability cover, certainly up to the limit of cover provided, its interests should coincide with those of the insured, and it may not be necessary to involve him closely in the decision-making. In some cases, within or in excess of the cover limit, there may be some tension or potential for conflict between the two interests, matters which it is for the responsible insurer to balance in the conduct of the litigation. If and when a significant conflict arises, say when there is a realization that if the matter proceeds the cover limit may be exceeded, the insurer should have regard both to his own interest and to the separate interest and exposure of the insured. This may, depending on the circumstances, require the insurer to pay greater attention to the insured's expressed concerns or to involve him in the making of decisions, as Mr. Justice Thomas suggested in Citibank at page 17 of the transcript. These may include, for example, whether and when to seek settlement and for how much, rather than to continue the proceedings. Manner and extent of such greater involvement of the insured are clearly matters of judgment and balance depending on the facts of each case. I'm going to continue the quotation in a moment, but importantly, what is being said here is that the insurer must take that into account and give some attention to the insured's interests and concerns. Not that the insurer cannot then take whatever decision it likes, as long as it's had proper regard to the insured's interests and can't objectively be said in its decision-making to disregard them. But then what's important, and this is what I was trying to signpost, this is the lead up to the signpost, that this is not some special Section 51 point. This standard of conduct, as Lord Justice Ord said, all this is pretty well what Sir Wilfrid Green, the then Master of the Rolls, said so many years ago in Groom and Crocker in 1939. And what he said was the right given to insurers is to have control of the proceedings in which they and the insured have a common interest. The insured because he's the defendant, the insurers because they are contractually bound to indemnify him. Each is interested in seeing that any judgment to be recovered against the insured shall be for as small a sum as possible. It is the assured upon whom the burden of the judgment will fall if the insurers are insolvent. The effect of the provisions in question is, I think, to give to the insurers the right to decide upon the proper tactics to pursue in the conduct of the action, provided that they do so in what they bona fide consider to be the common interest of themselves and their assured. But the insurers are, in my opinion, clearly not entitled to allow their judgment as to the best tactics to pursue to be influenced by the desire to obtain for themselves some advantage altogether outside the litigation in question in which the insured has no concern. So the test being posed there was a test that went, as I said, predated the Chapman line of authorities, and was setting a general code of conduct for insurers in how they should conduct litigation in which their insured was involved. And when the insured had an interest, the duty, which invariably the insured would, the duty was to decide upon the proper tactics. They're still entitled to decide on the tactics to pursue in the conduct of the action, provided that they do so in what they bona fide consider to be the common interest of themselves and their assured. And that would, of course, apply when there were uninsured elements to the claim, for example, if the limits of indemnity were inadequate, or if there was a significant deductible, or if some of the heads of claim were insured and some were not insured. That's typical in a product liability case, where the policy will only cover the consequences of physical damage or injury, but the insured may be exposed to contractual claims for economic loss arising out of the same incident, the classic case is a loss of substitution.
Where even if it's got a good defence, it's in the defendant's interest not to contest it. This contain a QC clause quite often for that very reason.
Yes, absolutely. And these are the balancing factors that the court has to weigh. Now, obviously, there may be a case where it could not properly be said that the insurers should have resisted settlement in the classic case my lord was alluding to. Let's say there's no QC clause to resolve a dispute, but the case is self-evidently one that should have been settled. But the insurers, because there was an off chance that their insured might win, decide to gamble on that 10% chance of running the case to trial. Now, it might be different if they're advised that there are reasonable prospects of success, then it's a difficult balancing exercise. But as long as they reach a bona fide decision about that, that doesn't render them the real defendant. What renders them the real defendant is if there's a fanciful chance of success, but they nonetheless go for it because they have so much money at stake.
Is there anything useful in Lord Justice Morritt's reasoning in the TSB Bank case?
Lord Indy, sorry, I didn't...
In the TSB Bank case, which you'll see Lord Justice Auld has cited immediately below the passage from Sir Wilfrid Green's judgment.
Well, my recollection of that case is that again is concerning the conduct of the insurers in the defence of a case, and it's the same principles. And the submission I'm making is that this is not some esoteric Section 51 line of authority. Where, although the Chapman line is on Section 51, the underlying principles of how an insurer should behave, and when it has, I use the word misbehaved as the contrast, it is not peculiar to Section 51. It is the essential basis of how insurers should behave when conducting litigation. And fundamentally, in our submission, it would be wrong to impose on insurers a liability under Section 51 when it is not being alleged, and with respect, it isn't being alleged, that they have not acted in what they bona fide considered to be the common interest of themselves and their insured. Second guessing that it might have been better to do one thing rather than another isn't enough. I take the non-disclosure of insurance as an example. In July 2013, Travellers was willing to allow Transform to disclose the essential ingredients of the cover, to tell the claimants that the policy only covered injury and to give them the years of cover. But Transform then took advice from the jointly instructed lawyers, and they said they were giving advice in what they regarded as being Transform's interests not to disclose the insurance. The Court of Appeal criticises that as flawed advice. Well, let's assume for the moment, putting aside the fact that the Court of Appeal was second-guessing the advice of experienced solicitors, let's assume for the moment that with the benefit of hindsight or on an objective analysis, it can be demonstrated that that was flawed advice and that perhaps subconsciously the solicitors had allowed themselves to be influenced by Travellers' interests on the insured claims. Can it be said that anything that Travellers did was other than bona fide in what they considered to be the interests of the insured? They said, yes, you can disclose those ingredients, but obviously you'll discuss it with the legal team and see what they say. As far as Travellers is concerned, the legal team is giving advice to the insured in having regard to the insured's interests.
Can you help as to what could have entitled Travellers to stop Transform from disclosing the detail of the policy?
Well, where Travellers did not want to.
No, what in law could entitle them to stop Transform from doing
They
it?
do, under the policy, they do have the right to control the litigation.
I see. So that comes into the control of the litigation.
And they would be entitled to control the insured claims, and through their interest in insured claims, they would say, because these are there are insured claims in here. We have a contractual right to control the insured claims, and in relation to the insured claims, we can say do not disclose.
If the solicitors had formed the view that it was in the interests of the interests of the insured in relation to the insured claims differed from their interest in relation to the uninsured claims, what would they have been obliged to do?
Well, that was a situation where they would have to take Travellers' instructions. If Travellers then disagreed, we would say that Travellers' control of the litigation comes through the insured claims. But it may be that there would then be a dispute between the parties, and Travellers would take it, then they would have to be separately advised. Travellers would be separately advised what their interests are, and it may be that would have to go to a QC clause, some form of dispute resolution. But the fact is that on this litigation, that didn't occur. And saying that hypothetically it could have occurred isn't an answer, wherein actually what Travellers was willing to do was the classic Groom and Crocker balancing exercise. That's what Groom and Crocker required Travellers to do. They were actually, my lady asked me, the legal right to refuse, but what's the legal obligation? The legal obligation under Groom and Crocker is not simply to have regard to their own interests. So the decision, whether it's a decision under the policy or not, the decision has to be made having regard to Transform's interests and balancing those interests. And where Travellers came to was, it's not in our interests to actually hand over the policy document itself, but it is in Transform's interests, and we're quite happy for this to happen, for the claimants to be told about the scope of cover under our policy. So balancing the two interests, that is the solution. And that's what they were prepared to do. Then Transform had its own decision to make about whether it wanted to do even that. They obtained advice from BLM and decided not to do it. That's all in the judge's judgment as to what Travellers were prepared to do. But the critical point of this, and I'm just using those facts to illustrate the point, the critical point is that the only obligation on the insurer is to adopt a course that they bona fide consider to be in the common interests of both. The fact that it is later judged to have been something that the insurers ought perhaps not to have done, that they perhaps could have taken another course. If they are genuinely trying to do it, the fact that they may make a mistake is not enough. It has to be a situation where the court says to itself, no insurer acting bona fide in the interests of both could possibly take that decision. And there's been no attempt by the respondents to prove that sort of conduct. What they've said is, adopting the judge's approach, Travellers weren't entitled to have any say at all in what was happening in the uninsured claims, even though, of course, they had their own interest in the insured claims. And was the problem that with the learned judge's approach, and it's why the Court of Appeal were right to reject it as going much too far, because of course Travellers had an interest in the uninsured claims insofar as what was done in relation to the uninsured claims might affect the defence and settlement of the insured claims and admission of liability. If Transform was to admit liability in the uninsured claims, of course Travellers has got an interest in that. Similarly, if Travellers wanted to admit liability in the insured claims, they decided that actually this case is going to fail. We don't want to run up any more defence costs on this. We are going to admit liability in the insured claims. Transform would have an interest in relation to the uninsured claims. They both have an interest. And the duty of travellers would be to decide upon the proper tactics to pursue in the conduct of the action, provided they do so in what they consider to be the common interests of themselves and others.
I can see why you say that travellers might have an interest in whether Transform should admit liability in the uninsured claims because of possible knock-on consequences. But did that fall within a contractual right of control? In other words, if the issue arises solely in relation to the claims by the uninsured claims, rather than something which, as it were, arises in relation to both and can't be separated out, possibly like disclosure of policy cover, then did that give travellers any right of control?
Well, the problem was, of course, that what was being tried was common issues in sample cases.
Well, I understand that,
So that's
but
that's
I'm just looking at this issue about admission of liability in the uninsured claims. By all means, put it under the general umbrella that there are common issues being directed to the trial.
What happens when an insured and an insurer are both embroiled in litigation, which has insured and uninsured elements? They will necessarily each have an interest in the other aspects.
I understand the interest, but my question is about whether they have a contractual right of control.
Well, they have the right to control the litigation once they're paying the defence costs. Let's bear in mind, they are paying for the entirety of the defence of this because they're contractually obliged to do so. They have no choice about that. And so what they are then doing is, and under the policy, they have a right to, there's a provision that says no admission of liability shall be made without the consent of the insurers.
That's in relation to an insured claim.
It is in relation to the insured claim, but they nonetheless, through their conduct of the insured claims, must have an interest in the uninsured claims. Now, whether that gives them a right to veto or simply to be consulted, it certainly is an interest because the respondents, they don't, although at one stage they say travellers, it was subject to travellers' veto, all they can actually point to is Transform saying, well, we would want travellers' consent, and travellers saying, well, we would want to be consulted about an admission of liability before it's done. So it's a critical issue in this case is whether travellers oversteps the line by being involved, which was the judge's case, the judge's approach, or whether travellers is entitled to go further and veto. Well, that isn't actually something that is pursued on the evidence.
But how do you distinguish between the insured and the uninsured claims in relation to the common issues, which were actually the major issues this side of quantum? You can't, I mean, a single defendant can't admit liability for 400 odd claims and then decline to do so for the other 197 in circumstances where there is no relevant difference between them. So distinguishing between what you do in one right and what you do in the other with a single defendant is a non-starter.
But that was my point about the common issues. That's the problem. There are sample cases with common issues, and it's in group litigation. So it's different. I mean, one scenario may be that you had all these claims pursued in county courts individually up and down the country. And you could make an admission of liability for the purposes of one action in one county court, and somebody may say, well, you admitted liability in that. You said, well, that was only admission for the purposes of that litigation. and there were commercial reasons for that admission, and it's not relevant to this litigation.
But if that can be done just because they're in two adjacent county courts, why can't it be done in a piece of group litigation?
Because here you are facing these hundreds of claims in one piece of litigation with a common issue and a common defence, all being run by with the same solicitors on the other side, and you are in that litigation, you are either fighting those common issues or you're not.
Well, technically, you could make admissions as regards some claims, but not others. But forensically, it's a completely unreasonable position to take.
It is absolutely impossible in this situation, but that goes to my point about, and this is why I was focusing on the question of the difference between involvement and the issue about a veto. And we don't really need to debate the veto, although I would submit that the group litigation does create a particular situation, which means that there is necessarily prejudice to the insurer's interests by an admission that Transform would purport to make in relation to the uninsured claims, which would not necessarily apply if you had a whole series of different pieces of litigation where an admission was simply being made for the purposes of the litigation. We've all seen that sort of admission. It's saying, I'm admitting it for this, but you can't use that admission against me for any other purpose whatsoever. It's just simply to resolve this litigation. But different context, Travellers clearly has an interest. And that's really in our submission as far as I need to go on this. If Travellers has an interest and is entitled to be involved, then it's entitled to have a say. Whether that say should prevail or not is another matter.
But does a point come where an insurance company, behaving properly according to the general rules, has to say, you're entitled to have your interests managed with us, but now you've reached the point where we can't look after both because our interests are different here. The interests of Transform being in getting rid of the claims which were uninsured.
Well, you then come down to the practicality of how is the defence going to work? You can't, it was suggested at one stage on the respondent side that there could have been two firms of lawyers, one representing Travellers for the insured claims and one representing Transform for the uninsured claims. Well, that's impossible. You've got one defendant. They can't have two teams of lawyers running different cases in court. You've got to have one jointly instructed firm.
Position between Transform and the claimants was exactly the same, whether they were insured or not. It was only different as between the defendant, the single defendant, and another party. I think the point that my lady makes would be unanswerable if one was dealing with separate parties.
But if we just push it on the facts of this case and Transform say, we've got our separate lawyers, it's in our interest to get rid of the claims that would cost us, as opposed to looking after the interests of the insurer in not having to fund the ones that would cost them. We need to disclose the insurance policy. We're going to do so, because that will rid us of those claims. Suppose.
They would also, when you've got these two people forced together, insurer and insured, the solution we submit is for them both to have regard to each other's interests. And in that situation, the parties would have to try and come up with a compromise situation, and that's what Travellers tried to do in this case. They said, rather than just, what we're happy for you to do is to tell the claimants that our policy only covers injuries and that it's for these particular years and it's only injury occurred. It was in Transform's interests to do that. Travellers didn't judge it as being in their interests for the entire policy document to be disclosed, because that would say all sorts of other things about the scope of cover and limits of indemnity and so on. And the law protects insurers against having to disclose their policies in this sort of insurance. But Travellers sort of went that part of the way to try and deal with Transform's interests. Now, that's the sort of conduct that one would expect from an insurer, bona fide, trying to balance their interests against those of the insured.
But that does depend, doesn't it, on the thing in question not capable of being divided as between the insured and the uninsured claimants. And for my part, I can see how you can say that in relation to the disclosure of the essential terms of the policies, because that's not a claimant-by-claimant concept, even though it may have claimant-by-claimant consequences. But where the issue is whether we make an admission or settle with a specific group, all of whom are uninsured, either because they're outside the period or because they're worried well. For my part, I'm not sure why the fact that the litigation is being treated as a group litigation and common issues being directed to be tried means that you can't, for commercial reasons, because they're uninsured, take a particular group of claimants and settle with them or make admissions to them.
Well, there's a distinction between settling and making admissions.
All right. But both of them have this in common, that they are claimant-specific, whereas the disclosure of the terms of the policy isn't.
You can't separate, can you, in that context, the disclosure point from the settlement point, because if you settled with the uninsured one, it would be on the basis that you told them you're uninsured in respect.
Oh, yes,
of
I assume it's happened by then.
Yes. Well, you've made that assumption, you've told them they're uninsured. And when it comes to settlement, again, if the insured comes to the insurer with a proposal for settlement, the insurer is entitled to have a say, in the sense that they're entitled to look at whether the settlement is going to prejudice their rights. And let's say, for example, there's an insured that's got lots and lots of money and is about to market a bumper drug which is going to be the complete breakthrough drug in a particular field. And they want to get rid of a piece of litigation in order to prevent their reputation being sullied and affecting the launch of the new product. So they go to and they've got this situation, some insured, some not, and they go to the insurer and say, well, I'll tell you what, I know you say these claims are only worth 5,000 each, but the insurer, the claimants say they're worth 10,000. So what we want to do to get rid of this litigation is just pay them what they want, 10,000, and they'll go away because that's all they're asking for.
Pay who, the insured or the uninsured claimants?
The uninsured claimants.
On the judge's findings, what was being proposed as the basis of settlement was an admission of liability. That was the judge's ground. So, I mean, you say...
And a drop hands, I think.
Yes.
Yes, but I mean, I'm not quite sure how this occurs on the facts, but am I right in thinking that the drop hands offer to the 228 worried well claimants was on the footing that there would be an admission of liability to those claimants? Right. And that's what the judge focuses on. She says the judge seems to say, well, there was no reason why, in the interests of the insured, Travellers should not have directed an admission of liability to the uninsured claimants, but withhold such an admission for the insured claimants. So one is straight back in the area that this would have had an extremely damaging effect on the defence of the 197 insured claims.
Because
it's not a without prejudice settlement, in other words.
And you're dealing with the same solicitors on the other side. This is the other distinction between, in county court dealing with one solicitor in Carlisle and another one in Exeter.
probably have to disclose a certain amount anyway. But the judge goes on to say it refused to consent even to transform making a confidential admission of liability. I mean, how would that have worked, the confidentiality?
As it so happens, Mr. Keating just says that's not right. The judge, his evidence, his witness statement is to the contrary. He says he never got that far. Travellers never did, but let's assume he did.
Suppose the finding is as the judge says.
Yes.
How would a confidential admission of liability have worked in the circumstances of this case?
Well, it's impossible because you make it confidentially and the solicitors know about it. And they come to the insured claims and they say, well, why aren't you admitting liability as well? Can I make some other points about this as well? You'll see, if you're looking at that passage in the judgment, you'll see that in July 2014, in the judge's judgment, she refers to the fact that Travellers had agreed to transform making a drop hands offer. So yet again, Travellers is looking at, is being entitled, we submit, to be consulted about a settlement proposal for the very reason I gave on the uninsured claims. They must have an interest. If they're defending insured claims and the uninsured, they must have an interest in what the insured does in relation to the uninsured. So they say, fine, we go along with that. That's acting bona fide in what they consider to be the common interest. They ask to be consulted about admissions of liability because that could also prejudice their position. And they're entitled to have a say, at the very least entitled to have a say, because it could prejudice their position on the insured claims. And that you have it, if the two people, the insured and the insurer, are in the same boat together, in the sense that they're both defending common issues on a batch of claims, some of which the insurer has a financial interest, some of which Transform has a financial interest, they've both got a right, both got an interest in what the other does. The policy gives Travellers the trump card in relation to insured claims. But they've also entitled to, at the very least, consult and have a say on the uninsured because of the effect on them.
But if that's what they say is ignored, there's no contractual way in which they can prevent the thing they don't want from happening.
Well, other than through the policy. It depends.
Well, I'm asking if there's something in the policy.
The only policy, the policy provision.
6B in the general conditions says, 6G, that no admission shall be made without their consent, but that's in relation to claims, and that must be the insured claims, mustn't it?
Yes, but the question is, an important question would be whether the admission that they are making, what are they doing? They are admitting, they will be admitting, if we go back to the common issues in the GLO.
I mean, the problem is surely that if you've got one defendant who is liable, if at all, for the entirety of the claims, then the power that the policy gives the insurer is a power to direct the way in which that one defendant conducts the 197 claims. But the procedural impossibility, it's procedurally impossible for the insurer, for the insured to conduct the case in relation to the 197 claims in a manner which is inconsistent with the way that he conducts the claim in relation to the 400 claims. Settlement is one thing, because you can settle with different people separately, subject to forensic problems. But if the question is disclosure, it's a binary question. You either disclose in relation to everything, or you disclose in relation to nothing.
And I was going to make the same point, my Lord, but in a slightly different way. The issue in the case, in the sample cases, and there were 4 of them, 2 insured, 2 uninsured, but they were sample cases because there was no difference between them as regards the issue. Were the implants supplied in breach of the implied term as to satisfactory quality? And it was comprehended that if the answer in relation to the sample cases was yes, then it applied to everything. And so there is the impossibility that's the context.
That's a forensic impossibility.
Yes.
Whereas in relation to disclosure, the impossibility was absolute.
Yes.
Whereas in relation to settlement, it was simply a matter of severe forensic embarrassment, which would have hindered the conduct of the insured claims.
But the one thing that cannot be said is that in our submission is that the insurer has no interest in that, which is the judge's approach. She says no, and the Court of Appeal rejected that. She says no interest, therefore no involvement. And that, our submission, simply doesn't stand with the authorities and the practical situation. You have here an insurer that has tried its best to comply with the Groom and Crocker standard, and yet finds itself still being penalised in costs. So our submission is, I mean, we have jumped ahead, I think, but I was happy to answer the questions. We have actually jumped ahead to the judge's approach. But it is, my learned friend tries to say that there's some sort of conceptualisation issue that we're overlooking, that we're conceptualising this as if it was a single claim. But that sort of conceptualisation approach simply overlooks the key and fundamental point that this was a piece of group litigation with common issues. And they were going to be tried so as to determine all the claims. The other point, of course, is, and this is particularly relevant to the judge's approach, is when one looks at the timing of what she's talking about. It's the admissions point comes up in January 2015. And yet this is very well down the line, but she used that as part of the justification for travellers to pay all of the costs. Even if there is some criticism of travellers to be made and they do somehow go on the wrong side of the line in January 2015, what possible justification in our submission could there be for travellers to be ordered to pay all the costs before that date? Absolutely none. It hasn't, and causation, we say, must be an ingredient, because this is not, travellers regards this order as penal. The jurisdiction shouldn't be penal. It should be looking at what the non-party has done and what costs have been caused by what the non-party did. And that's why, in a sense, part of our proportionality case is misunderstood. We're not talking about proportionality as a quantum issue, but proportionality to what travellers did in just simply funding the defence of the common issues. In this respect, what they did in terms of admissions, having the entire cost liability, including all the individual claims costs, which were outside the cost-sharing arrangements, all of that being visited on them. I know my learned friend does rely, and I'm sort of going back a bit in my submissions now, on the authorities, on the general scope of the jurisdiction. But in our submission, they don't undermine the approach that I've been submitting to be adopted by my lords, the Chapman line. And if I can just take this opportunity just to show you a few passages in the authorities on which my learned friend relies. There's at tab 9, there's the Dimmock's franchise case. That's 1122 in the electronic bundle, first volume of authorities. And this was a Privy Council decision on a case from New Zealand, but the court held that the same principles could apply. This was an outside company funding for its own financial interest because it had an all-monies debenture on one of the defendant companies. And this was all family related. It was all within family. It wasn't an outside company. And learned friend relies on a passage at page 1130 between D and E. There's, although costs orders against non-parties to be regarded as exceptional in this context means no more than outside the ordinary run of cases where parties pursue or defend claims for their benefit and at their own expense. And he said, well, the GLO's outside the normal run of cases, and that's it. Therefore, the jurisdiction is engaged. Our submission is that that is not giving full effect to what was actually said in the case, because it then goes on to discuss the circumstances in which orders should be made and can be made. It talks about, firstly, at just below letter E, pure funders, saying generally discretion won't be exercised against pure funders. And then just above G, 3, where, however, the non-party not merely funds the proceedings, but substantially also controls, or at any rate is to benefit from them, justice will ordinarily require that if the proceedings fail, he will pay the successful party's costs. Non-party in these cases is not so much facilitating access to justice by the party funded as himself gaining access to justice for his own purposes. He is the real party to the litigation. And it's significant, we submit, that at letter H, the board regarded it as being consistent with that approach that Lord Justice Phillips described the non-party underwriters in Chapman as the defendants in all but name. So that's plainly what the board had in mind as the circumstances in which an order should be made. And
I seem to regard that as flowing from the combination of commercial benefit and a right of control, and that seems extraordinarily wide.
Well, he's adopting what I think the critical words, my lord, in that is gaining access to justice for his own purposes. And that may be what he's actually where the limitation is in that, because someone, for example, a legal expenses insurer, which is all a liability insurer is while he's funding the defence costs, he's a equivalent, same situation as a legal expenses insurer, is funding the litigation, but not gaining access for his own justice for his own purposes. And neither actually is a liability insurer. The last thing that a liability insurer wants is for his insured to be sued. It's contrary to any other type of funder.
But if sued, he wants him to win.
If sued, he wants him to win. But he's not seeking to gain access to justice for his own purposes. He is doing what he is doing because he is contractually obliged to do it. That doesn't make him the real party.
And because he's dealing with a defendant rather than a claimant.
Yes, absolutely. That's maybe the difference between a subrogating insurer seeking to recover its own outlay, which was one side of the Chapman dispute, and the insurer for the defendant in Chapman on the other side of the dispute, both of whom were exposed to Section 51. And as I've indicated before, that was the reciprocity which was being referred to in that case. But it's gaining access to justice for his own purposes. And what the board had in mind is also illustrated by what's said on the next page, at 1131 at letter A, where it says, some reflection of this concept of the real party is to be found in CPR, which allows a security for costs order to be made where the claimant is acting as a nominal claimant. Now, that's not, it's only said to be an indication, but it is an indication of what the board had in mind when they were referring to real party, and what they had in mind when they were referring to Chapman. The defendants in all but name was what the insurer would become if they were defending the litigation, as in that case, having regard exclusively, or perhaps predominantly, improperly predominantly, to their own interests, to the exclusion of any interest of the insured. They would not then be merely fulfilling their contractual obligation as a liability insurer. They would be making themselves the real party and effectively turning the insured into a nominal party. That, we say, is key to understanding what the board was getting at in that case.
Is there a distinction between a liability insurer and, say, a debenture holder of the type in this case, along these lines, that the debenture holder has an interest in funding his company's defence of the litigation, perfectly understandable interest, but is making a voluntary decision to intervene by funding, whereas a liability insurer is doing no more than discharge a contractual obligation which he incurred before any litigation became threatened or known about, and only exercising rights of control to the extent covered by the contract.
Lord, that identifies the important distinction, why there is a separate line of authority for liability insurers, because of the very different circumstance of a liability insurer compared to other types of funder. And if I, just before I go on to the next case, spend a bit of time dealing with that, because it is one of the topics that I did want to deal with in the course of my submissions. The insurer has entered into a contractual commitment to defend and indemnify the insured against claims, the existence of which will be unknown when the policy is entered into. If they knew about it, they'd exclude it. It would probably be covered under an earlier policy, if there was one. And the commercial purpose of that contractual commitment to defend and indemnify is not because of any interest that insurers might have in claims that are made. On the contrary, the best result for insurers is that no claims are ever made against their insured. Rather, the commercial purpose of the insurance is to protect the insured against what otherwise would be potentially financially ruinous defence costs and damages liabilities. Insurers will only make a profit if there are no claims at all. Otherwise, they will share a common interest with the insured in defending the litigation, if at all possible. And as I've said, the insured's interest may be financial because of the uninsured exposure, or reputational, or both. And it would be exceptional, in the sense of being outside the norm, for the insured to have no interest whatsoever, whether financial, reputational, or otherwise, in the litigation, and for the insurer simply to be, for the insured simply to be a merely nominal defendant. By protecting, and it's important also to see the function of the insurance, and important not to allow Section 51 to undermine it, because the economic purpose of the insurance is to allow businesses to survive claims being made against them, and to give them access to justice, so that if there are claims which are capable of defence, they have an opportunity to defend themselves. One of the problems with a too liberal use of Section 51 against insurers is that it will necessarily discourage insurers from robustly defending their insureds, consistently with legal advice, and would thereby undermine the commercial purpose and function of liability insurance. The way the respondents seek to get around that is by saying that these principles may be relevant to a claim or claims which fall entirely or partly within the ambit of a policy, but the insured, they seem to say, has no protection or no equivalent protection when it defends its insured in circumstances where it faces insured and uninsured claims raising common issues. But the approach that learned friends are adopting in this case, and seeking to persuade the court to adopt, isn't limited to this sort of GLO case. It's important to understand its ramifications. Let's take, for example, the New Zealand Forest Products case, where the insurer was held to be liable, albeit in that case after the event, but let's assume that they'd been held liable before the event, to pay for the entirety of the defence costs of a number of defendants in a big corporate action. Only one defendant, one director, was insured under the D&O policy. But because his defence raised the same issues as the defence of other participants in the litigation, the insurers were held liable to fund all of the costs through him, just as in this case, exactly the same situation.
Of the defence of the common issues.
Defence of the common issues, even though, and we have the added ingredient there, that the insurers end up funding the defence of all the other defendants because they all had the same firm of attorneys.
They ended up funding the defence of the insured defendant.
Yes.
The benefit to others was entirely incidental.
Yes, but they gained the benefit from it. And
Yes.
as a result...
That was a case about, basically, the contrary suggestion was that there should be some kind of quantum merit based on the receipt of an incidental benefit. So it's a somewhat different issue to the present case.
But what of the position of the claimants who may have had separate claims against the various defendants? Some may have only had claims against some of the defendants. Maybe if let's assume that there's one director who was a director for a certain period of time, others who were directors at other periods of time, but there were common issues.
And the issue wouldn't have been common to that extent.
Well, there may have been, because it may have been a common issue as to the financial state of the company throughout. And it's possible to envisage that there may have been some issue as to the treatment of a particular asset in the balance sheet, which was in the balance sheets at regular intervals, and people invested on the basis of the state of the balance sheet, and he was only a director at one time and was on the hook for that. But it was a common issue as to whether including the asset at a certain value year after year misrepresented the value of the company. Do all the claimants, if that was a Section 51 case, have a claim against the insurer under Section 51 because their funding of the litigation through the insured claim facilitated the defence of the claim by all the other defendants? It's the same point. So I'm simply making the point that this is not limited to the particular group litigation situation. There can be cases in which there are other uninsured elements in the claims. There can be other cases in which cost-sharing approaches are adopted, which would expose the insurer to the same. That was sort of a digression in answer to a question about the role of and function of insurance and the distinction of liability insurance. Can I just return to Deutsche Bank, which was the other authority Malone and friends rely on? And that's at tab 8 in the authorities. And page 1106. And the passages on which the respondents rely are in the postscript at 1120. There's another non-insurance case, and it addresses the approach in Dimmock's. And learned friends rely on the adoption there at 62 of the observation of 3 members of the court in Petromac: the exercise of discretion is in danger of being overcomplicated by authority. The Privy Council contains an authoritative statement of the modern law, explains and interprets the Symphony Guidelines, and it goes on to deal with the Privy Council's explanation of what exceptional means. They also go on to, over the page at the end, to say that little assistance is to be gained from the citation decisions at first instance. Well, apart from the Citibank case, which has been adopted by the Court of Appeal, we haven't relied on any decisions at first instance in support of our main submissions. But it's important when one's reading this to note, firstly, it is just a postscript. Secondly, it endorses the Privy Council approach in Dimmock's. And thirdly, as we can see from paragraph 19 on page 1111, that there is an extensive quotation from Dimmock's, which includes the passage which I've referred you to, up to 1112, including, again, the reference to Chapman.
I mean, it's all very well to say the only real question is whether it's unjust, but unless the punters are told what might make it unjust, parties who need to know what the risks of litigation are, which costs are a very important part, particularly under the pre-LASPO regime, are not in a position to make sensible decisions. So it's actually not very helpful simply to say. It all depends on whether it's unjust.
At least, Lord, exactly, and at least in the liability insurance field, there is detailed guidance as to what liability insurers should and should not do. And as I said, that's not, although that's been developed under Section 51, it in fact goes back to Groom and Crocker in the 30s. And perhaps what is most significant in this case is that Travellers, in particular through Mr. Keating, was only too well aware of these authorities. And made efforts always to try to balance the interests, and it's not suggested at any stage by the respondents that he didn't bona fide try to do his best to have regard to Transform's interests.
Is bona fide, is the test not objective?
I was only quoting from Groom and Crocker, and that the only problem with objective is it depends what objective test you're applying. If you're saying it has to be reasonable, then that can probably equate with bona fide, because if something is a way of conducting litigation that a reasonable insurer could have adopted, then it's within the range of what is bona fide. I don't think it means bad faith in that sense. It means genuinely. Objective in the sense that no reasonable insurer could possibly have adopted that course, I don't disagree with that. If you get to the stage where you're reaching that level of condemnation of what the insurer has done, it's difficult to describe that as being bona fide in the interests of the insured. I'm drawing a distinction between sort of bona fide in the strict sense of bad faith and bona fide meaning genuinely and reasonably. And so that's as far as it goes. And interesting that paragraph 25 on page 1113, when the court moves on to summarising the position, it's talking about the third party effectively controlling the litigation and doing so with a view to obtaining a personal benefit. Now, that's expressed in general terms because it's a summary. The more detail for liability insurers is, we submit, to be found in the Chapman authorities, and that's the basis on which Travellers conducted itself when it was...
What sort of fund are we looking at in the Deutsche Bank case?
In the Deutsche Bank case, it was there was an order against a sole director and shareholder of the defendant company to pay the costs of a case that had been the subject of a 44-day trial.
So it was a company stakeholder?
Yes, and it was the defendants had put in a counterclaim for $8 billion. And this was all, the court said, at the instigation of the sole director and shareholder. It's a very different case from a liability insurer defending its insured.
It raises all sorts of different issues. I mean, obviously, a litigation which a company as party is normally controlled by the directors.
But this was he was the sole director, and he was the shareholder. But the court held that he personally was the real party to the litigation, and he was using the company as a vehicle for this $8 billion counterclaim, which took 44 days to
Would the result have been different if he hadn't been a shareholder but simply a particularly pig-headed director?
I suspect it would have been. It should have been, because the company would still be the substantive defendant. And the company wouldn't be the nominal party, and the case would be conducted in the company's own interest.
I mean, I have some hesitation about accepting that the company can become a nominal party simply because the shareholder will benefit by its success in litigation.
Yeah.
There is the basic distinction, which is this was all voluntary, whereas you say the liability insurer is not acting.
Yeah, I mean, what must be remembered is in this case, the shareholder is funding the litigation so that through the company he can obtain a significant financial benefit. I think it's maybe the counterclaim that is, it was the huge counterclaim that drove that decision rather than defending the claim itself. So in a sense, the company's there acting as a claimant for the benefit of the shareholder. But again, sometimes if the company does have a reasonably arguable claim, it's difficult to understand why a shareholder shouldn't be entitled to stand behind the company and support the company in pursuit of its claim without being penalised in a personal liability for the other side's costs.
Another context, that of security for costs, a company will not be able to say that its claim will be stifled if there are stakeholders, such as shareholders around who could fund it.
Yes, there's actually a Scottish case rather similar to this, which Lord Hodge decided at first instance, and he was upheld on appeal, where that very point was made. The court refused to make an order for costs against the director and referred to Section 726 of the Companies Act, dealing with security for costs in support of its reasoning.
Well, one of the fundamental points in our appeal is that the approach of the judge and of the Court of Appeal is letting Section 51 get out of control. And that's a real problem. And there may be cases at the margins where one says, well, this shareholder really has overstepped the mark. But once you start saying, well, it's all a matter of what's just, then you do end up with financial engineering. You do end up simply doing a bit of financial readjustment at the end. Now, that may be all very laudable against some other context, but Section 51, insofar as it's applying to non-parties, ought to be reserved for cases where there's a really good reason for saying that someone who isn't a party to the litigation should nonetheless be visited with the cost consequences of the litigation. And it would be wrong if Section 51 was to end up being used to stifle shareholders from trying to support companies in pursuit of legitimate claims, what they believed were legitimate claims, even though they turn out not to be. It would be wrong if Section 51 was to be used in such a way as to stifle the insurers' defence of their insureds, for fear that if they defended them too assiduously, they would end up having to pay way over their limit of indemnity for which they receive no premium. And of course, when one comes back to insurers, who will end up paying for this Section 51 order? Of course, initially, travellers will write the cheque, but what's going to happen to premiums? The law firms in this case will go away with a very large cheque, and the businesses that travellers insure will face increased premiums, because that's how it works. Insurers recover their claims costs through higher premiums. And that, it was dismissed a bit in earlier on in the Chapman case, but perhaps, and as we say this in our case, modern times we've learned that this is actually more of a significant consideration, because one of the major reasons for the abandonment of the CFA scheme was the fact that the people who ended up paying for it, although directly were insurers, ultimately it was the business community through higher insurance premiums.
Well, there's a school of thought that says that the socialisation of costs across the largest possible base in that way is a good thing, but we're in the realms of policy extending long way outside that of law.
We are, but one can see the consequences, but the socialisation, and I'm afraid, only ends up enriching lawyers who have more cases to run, rather than the common man. In this case, none of these claimants, none of the respondents will receive any damages at all, but the lawyers will receive many millions of pounds. But it is an important, in our submission, important warning as to what can happen if Section 51 is allowed to get out of control. If it's just an unlimited, unrestricted, whatever seems just and fair. And insurers will inevitably fear that it will always be seen to be just and fair to clobber the insurers. They're not a very attractive community in the eyes of some sections of the judiciary. But they perform an economic function and they enter into contractual commitments and they comply with them. My Lords, I think I've only got just over 10 minutes left.
We haven't heard on reciprocity.
Yes, I was going to look at reciprocity. I've been answering, I think the questions I've answered have probably covered various aspects of my submissions. But fairness I think I've dealt with. The only thing I would say about, additionally about fairness, is that if one's having a touchstone of fairness, which the Court of Appeal adopted, the critical question is whether it's fair as against travellers, not whether it's fair in some abstract sense. But the Section 51 test must be whether it's fair to impose on travellers a liability for Section 51. And where we say the court went wrong is not to look at it through that prism at all, but just to think about what might be fair overall. And one has to bear in mind that it's always the case that a claimant takes the risk when starting a claim, firstly, whether the claim will be successful, but also, secondly, whether the defendant will be insured or good for the money if it's not insured. That is a speculative risk that a claimant always takes, and what these respondents took when they entered into the group litigation. But and one can ask, well, what would the position have been if there had been 1,000 claims, only one of which was insured? According to the Court of Appeal, the result would have been the same. Travellers would still have been obliged to fund the common defence of all 1,000 by reference to that one single claim, would only have been liable to indemnify that one single claim if it succeeded, but would be liable for the costs of the other 999 claimants. Now, one particular aspect which learned friends focus on is the supposed windfall. They say there is a windfall to travellers if an order isn't imposed. It's important, firstly, to identify what the Court of Appeal regarded as the benefit, because they say benefit and burden. The benefit they identified, this is paragraph 32 of the judgment, was the benefit from a successful outcome. A successful outcome for travellers would be transformed defeating the claims. If that had happened, no damages or costs payable to the claimants, and therefore the windfall issue would have arisen at all. The potential benefit of a win for Transform or travellers would simply be recovering as much in defence costs as possible. There would necessarily be irrecoverable costs. That is the basis for the supposed windfall, and that's the windfall which one needs to address. Respondents say that the Section 51 order creates a level playing field. Well, the concept of a level playing field, which I think learned friends derived from the Eli Lilly case, was something that was supposed to operate only as between claimants. The idea was that if there wasn't this level playing field of cost sharing, you would never get a claimant volunteering to be the lead claimant because they would carry the can for all the costs. There is nothing in the Eli Lilly case, the Access to Justice report, or the cost sharing rules to suggest that the level playing field concept applies to the defendants or their insurers, in particular to the insurers, as regards this cost recovery aspect. Now, learned friends try and postulate a windfall argument based on some sort of hypothesis of travellers not having funded the uninsured claims, and it said that they wouldn't have proceeded if travellers hadn't funded the defence of all the claims via the insured claim, via their contractual obligation in respect of the insured claims. Well, firstly, the contractual reality is that travellers had to provide that funding. It's not a windfall benefit to them in any sense, they just had to do it. They had no choice. Different in a case where someone does have a choice whether to fund or not, but they don't. And there's no evidence to suggest that travellers' conduct in the defence of the litigation was in any way motivated by the cost-sharing provisions of the GLO. So that is inappropriate. And it's also that there's a certain illusory element to this windfall argument. Travellers, as I've said, had to defend the common issues because they were contractually obliged to. The funding of the uninsured claims was only indirect because they shared the same defence as the insured claims. If the claims had failed, and this is important as part of an analysis, the costs would have been recovered by the from the unsuccessful uninsured claimants by virtue of Transform's independent rights against those claimants. Travellers would have had no right against those claimants. Travellers would, of course, have recovered its costs for the defence of the insured claims from the insured claimants. The only way that Travellers gets its hands on the money that comes from the uninsured claimants is through the rights of subrogation that it has acquired through its funding of the defence costs for the insured claims. Again, it's an indirect way of getting it. They have no legal entitlement to those claims those costs directly. It's simply that they are getting it because Transform receives the money and Travellers has only received part of its outlay from the insured claims. It then has rights of subrogation to that money. If all the claimants were successful, of course, Travellers would only have ever been liable to provide an indemnity for the claimant's costs in the insured claims and for those claimants' damages. They would never have been liable for those claimants, for the uninsured claimants' costs. And the supposed windfall only arises because Transform was impecunious at the time of settlement. If Transform wasn't impecunious at the time of settlement, Transform would have paid the claimant's costs on the uninsured claims, Travellers would have paid the claimant's costs on the insured claims, and that would be that. And there would be, of course, no recovery for any of the defence costs. So this supposed windfall only arises because of Transform's impecuniosity at the time of settlement. Respondents try to adopt the Court of Appeal's view that it was fanciful to suppose that when the policy was entered into, that it was expected that claims for defective products would be brought by a random mix of insured and uninsured claimants. There was no evidence to support that, and it is...
on product liability claims,
demonstrable.
in circumstances where cover is limited to 3 or 4 years, given that these are long-tail claims, this is absurd.
Yes, it is absolutely absurd. And yet they seem to treat this as exceptional, as though no one could have foreseen this sort of situation arising. That was at paragraph 34 of the judgment. And it is just absurd. And respondents also say there's some sort of anomaly about this windfall, but there's nothing anomalous about it. It's just how it's just a function of, on the one hand, the cost-sharing orders, and on the other hand, the contractual arrangements for Transform's insurers. Now, the judge said that Travellers took no risk in the funding of defence costs because those costs would be repaid if the claims failed. That appears to be based on a premise, and I think the Court of Appeal relied on it, but it's based on the premise that the funding was somehow voluntary. You know, when you say someone took no risk in doing something, it's though they had a choice in the matter. They didn't, they just had to do it. So it's simply not a question of taking no risk. And the judge, again, this may have influenced the Court of Appeal, the judge also said, this again is paragraph 34, that Travellers somehow bargained to pay something in respect of the uninsured claims. They bargained to pay for the costs. Again, that appears to be premised on the basis that they voluntarily fund the uninsured the claims defence and bargain for the risk that they're going to have to pay the costs. Again, that's not the reality. More fundamentally, though, the implication of the Court of Appeal's decision and the respondent's case in support of it on this aspect is that Murphy and Young in the Court of Appeal on legal expenses insurance was wrongly decided. Because in that case, that applied to legal expenses insurers who fund the defence. They don't exercise any control or influence, and the Court of Appeal made it plain that its approach to this reciprocity argument was free of any question of control or influence because they didn't regard what they said about the disclosure of the insurance as being in any way decisive. So it's just a freestanding point.
The ground, surely, was that Murphy, because it was only legal expenses insurance, there was no interest in the litigation on the part of the funder. So it failed that half of the test, if indeed it is the test.
But the Court of Appeal, the reciprocity approach is you take the benefit of cost recovery from everybody if you fund the defence. And so you must take the burden of paying everyone's costs. But exactly the same point would have applied if Travellers was merely a legal expenses insurer. They would, of course, not have any interest in the outcome of the litigation, but they would fund the defence of all the claims. Let's say that there was only a period when they were on risk, but that period did them no good because they had to cover all of the defence costs expenditure if it was related to claims for occurrences in a certain period, for their activities during that period. But they would have the benefit of getting a full defence cost recovery in exactly the same way as Travellers. So that maybe is a long-winded way of getting to the point that my lord was just making to me, that on the Court of Appeal's approach, an interest in the outcome of the litigation becomes irrelevant. It's sufficient that you gain a benefit of full defence cost recovery if you win, that you should be subjected to the burden of a full cost payment if you lose. And if that can't be achieved through the indemnity provisions, then that must be achieved through Section 51.
Well, it's confusing the position of the insured and the insurer. Travellers would recover if it won, and Travellers would pay if it lost. That's not the same question as what part of that is a liability under the insurance policy.
And that's where the Court of Appeal have departed from. They've just really ridden roughshod over the contract, and they've treated the policy as if it covered all claimants' costs in group litigation, when it doesn't say that.
But that approach is consistent with the real party approach, isn't it? That although if you're a funder but you've got no interest or no direct interest, then you can't be regarded as being a real party.
Exactly.
I'm
So-
afraid you're running out of time,
Yes, I
Mr.
have.
Edelman.
Yes, I think I have. And I think that's all I wanted to say anyway. I think there was only just one small point of reciprocity I wanted to say. Even if you were against me on reciprocity, it must be limited, the order must be limited to the equivalent to the common costs that travellers would have recovered. If it's reciprocity, then rather than having to be ordered to pay not just the claimants' common costs of prosecuting the claims, but all their individual costs, it ought to be tit for tat. But the Court of Appeal went further than that and ordered travellers to pay all of the costs. I'm quite happy to lose 3 minutes off my reply, because my learned friend is entitled to the same amount.
Thank you very much. Mr. Lynch, do you follow? Mr. Preston.
Well, may I start where my learned friend started, with looking at the issues that arose in this litigation and in the 4 sample cases for trial, because that, in my submission, is really the key to understanding what separates the parties here. In a product liability claim, where one is suing the manufacturer, one can, of course, have litigation where there is a single knockout blow issue that affects all claimants. Is this a defective product? And that may involve issues of law and fact that are exactly the same in all cases. And that, of course, would be conventional in a Consumer Protection Act claim, where you're looking at a product and the circumstances that the court is being asked to take into account in determining whether it's defective are generic circumstances that apply to everybody. The packaging that comes with the product, the warnings that are given by the manufacturer, etc. And in some group litigation, of course, the courts are quite willing to say, well, the proper way of resolving the litigation is to have a trial, not of lead cases even, but the trial of a preliminary issue. And that issue might simply be, is this a defective product? Yes or no? And in that context, where you have a mix of insured and uninsured cases, of course, you have a single defence team defending that issue, taking into account the interests of the insurer and the insured, because they both have an interest in the outcome of that generic issue. And if asked the question, what about admitting that generic issue? Yes, that would be forensically very difficult to admit that it's a defective product in one group of cases, but deny that it's a defective product in another. But that's not this case in my submission, and that is the key to understanding this. This litigation was unusual because although it may have looked like product liability litigation, and for insurance purposes, of course, one uses that term more widely, but these were breach of contract claims in which each claimant was alleging a breach of her individual contract. And the difference there legally is that the focus necessarily is on what was agreed by this particular claimant, what are the terms of that contract. Of course, they all have the same legal implied term that the goods must be of satisfactory quality, but in determining whether goods are of satisfactory quality in each contract, the court would have regard to the circumstances specific to the creation of that contract, whether warnings were given, for example, whether advice or promises were given to that claimant, what representations were made. And so the three critical ingredients of liability in each case. One is what promises were made to the claimant, what was said to the claimant, that has bearing on what they're entitled to expect. Secondly, what warnings were given by the defendant, and I'll take these in a moment. The defendant relied upon warnings given in individual cases. That may affect the position. And thirdly, and perhaps most importantly, what was the quality of the particular implants supplied to that particular claimant?
Where is the order identifying the common issues?
Well, the common issues, Malone and Friend took you to the GLO, which identifies the GLO issues. So far as the preliminary issues for trial in the sample cases are concerned, that is in the case management order in May 2013.
There's
Just take it
Appendix
a moment.
2, tab 8.
We have a page.
MS 461.
Thank you.
Page 91.
We need a Rosetta.
At the bottom of page 91, just to jump ahead a little bit in my submissions, the paragraph starts, the following common issues shall be determined in the sample cases. And one has to be very careful here.
I'm so sorry, where are you?
Paragraph 2 of the order. Bottom
Yes,
of page
thank you.
91. The following common issues shall be determined in the sample cases. And that phraseology, the use of common issues, was used for case management purposes quite loosely. And
we
one
got
can see that.
the issues on the top of the following page. The first issue is whether the implants were in breach of the implied term as to satisfactory quality. So it's being assumed that there is such an implied term, that nothing has been said to exclude it. In what respect can it be said that any of the claimants was in a different position to the others in relation to a term implied by law?
The existence of the implied term, of course, that's the same in each case. But whether the term was breached in each case was fact-sensitive, and the reason for that is because of the position taken by the defendant in the sample cases. Transform took the position that each claimant has to prove that her particular implants contained substandard gel. The background here to the litigation was that the majority of PIP implants, we always said, contained substandard industrial-grade gel. But it was never the case that every single implant was substandard. There was heterogeneity across the board. The background reason for that being that the manufacturers would put medical-grade silicon in when the inspectors were coming round. As soon as the inspectors leave, change the barrels and the industrial grade goes in. So our case on the pleadings, we said that there is a true generic issue here. We called it the Russian roulette argument. And it was our case that, leaving aside for the moment individual promises and warnings given in each contract, which would still be individual, but forensically, the central plank of the litigation, we said, was that as a matter of law, if we prove that the risk of rupture is above a certain threshold with these products generally, and a particular proportion have substandard gel, then as a matter of law, in contract law, each claimant should be able to say to the court, because I have an implant that is one of this particular type, it's substandard. Even if I can't prove and shouldn't have to prove what the particular properties of my implant are. So even if it's an implant that is absolutely fine with medical grade gel, the claimant should be able to say it's one of a type and therefore it's substandard. I shouldn't have to have it removed and tested in order to demonstrate by its intrinsic properties that it's substandard. That was our case.
Is your submission, therefore, that this whole approach of defining the 4 test cases was misguided because none of the others would have been bound by the result? They would each have been entitled to, the parties would have been entitled to litigate every single one again, because that doesn't seem to be the basis of the order.
But my Lord, no, precisely the opposite in my submission, because if the defendant had accepted that this Russian roulette argument is the only issue in the case, then the court might have proceeded in a different way and dealt with a trial of a preliminary issue, a common issue across all cases. But it was because the defendant was saying, and throughout, the judge referred this to in her judgment, throughout the conference notes, in the joint retainer, Transform and Travellers in that joint retainer, being advised throughout that what I call the Russian roulette argument was a bad point. They had a good defence to that. Leading counsel's advice was that no, each claimant is different, each must prove by reference their own implants. So for that reason, the court proceeded by way of 4 sample cases so that one could determine breach of contract in each of those 4 sample cases. 3 of them were rupture cases. It was a worried well case, chosen by Transform so that the court could have a worried well case to consider the issue in as well. And so within the scope of what are called the common issues for case management purposes, the true position is that there was a mix of a true common issue in the New Zealand product sense, namely the true generic knockout blow the Russian roulette argument, the resolution of which would be precisely the same in every case, and the court would need to resolve individual issues in each case that are also relevant to breach of contract. And can I just illustrate that a little on the pleadings and the way it was put in the pleadings? There were 4 cases. I said was the worried well case, but the pleadings are very similar in each case, and we've got one example in there. It's a case of who happened to be an insured case.
Yes.
And in the particulars of claim, which is MS 373.
Yes, Mr. Preston, do bear in mind the order that we made at the beginning of the proceedings.
My lord, yes.
These proceedings are...
Having had a CMC or two at that point, I think at least 2 CMCs by then, when the issues had been discussed between counsel.
Yes, but you're being live broadcast all around the world on the internet.
I'm sorry, my lord?
As you speak, you are being broadcast live all around the world on the internet.
Yes.
So when
Anonymity.
I'm sorry? Oh, I'm sorry, I hadn't appreciated.
Well, we made an order at your request. So
Yes.
it's important that it be complied with.
Yes, indeed. I'm better than mine. I apologise. And so those issues then for trial encompassed both a true common issue and individual issues. And looking at the pleadings, forgive me, yes, I see the point, but looking at the pleadings at page 373 of one particular sample case.
Do you happen to know what the alternative?
It's A2/1, page 3, I think.
Are we in it?
Page 3.
Page 3. Right. Yes.
And so just on the first of that shopping list of 3 topics that are individual, firstly, the promises made. In this particular case, at the bottom of the page, it starts at subparagraph 1, defendant using only cohesive silicon implants over the page. Paragraph 2, implants would not rupture unless subject to a strong impact. Thirdly, it was cohesive, could and wouldn't leak. And then 4, could be expected to last longer than 10 years. And that continues through paragraph 12 with the information leaflet given, and over the page, advantages and disadvantages of this particular type of implant. And then at paragraph 13, our assertion that the oral and written statements were of importance to and relied upon by the claimant. And that's part of that legal question of determining satisfactory quality by reference to the circumstances that apply in that particular contract, including representations made. And then at paragraph 16 over the page, she goes back to the clinic and further representations are made at 16, 1, 2 and 3 about the strength of the implants. And just under subparagraph 3, the claimant's mother invited to stand on one of the implants to demonstrate its strength. These are highly idiosyncratic individual circumstances about the nature of promises being made to claimants, and there will be a wide variety of circumstances across the group in that respect. And then at paragraph 22, which is page 10. Sorry, page 13, is it? Page 13, forgive me. We have at paragraph 22 the claimant's case, which is really what I call the Russian roulette point, that because they form part of a group, and the circumstances then set out, the generic circumstances, in the light of all of that, then listed over the page, that those are matters that can be taken into account, and then particulars of breach of contract set out. So that was the claimant's case. And in the defence, MS page 405, A2 page 35, paragraphs 13 to 20, the defendant then relies upon representations made by the clinic, and set out at paragraph 13 and 14, reference to a patient guide over the page, at paragraph 17, and over the page reference to risks and conditions, in particular risk of rupture. And so on through to page paragraph 18, where the defendant responds to the representations the claimant had relied upon about promises being made, no admissions made, and denied that those statements amounted to pre-contractual statements. And then paragraph...
No, it's saying that the defendant's case is that they were pre-contractual statements, not terms of a contract.
Yes, yes, precisely. They were not terms of the contract. So there's going to be an issue there in that case as to the status of those representations. And then reference to the price paid. And paragraph 20, reference to the discussion about risks. So defendant relying upon warnings given, which would be different in each case.
Well, would they? I mean, one struggles to think that a member of the defendant's staff could remember each individual case and how the meeting went. One assumes this is all derived from standard operating procedures which competent employers would apply on every occasion.
Well, we only have this pleading in the bundle and all, but in principle, the point of this is that these are not knockout blow generic points in the New Zealand products sense. These are individual facts which are unique to each case. And of course, one may well be the case that there'll be a lot of cases that share a lot of these features on that particular point on warnings. When it comes to perhaps the more important point about the quality of the implants and breach of contract in that sense, defendant sets out their position at paragraph 36, which is MS 412, page 42, paragraphs 36 to 39. And at paragraph 36, a defendant's case that the issue of whether the PIP implants supplied were a satisfactory quality is to be determined by reference to the characteristics and composition and construction of those particular implants, and not those of PIP implants in general, in respect of which the claimant is in any event put to strict proof. And then at paragraph B, the matters set out by the claimant in that respect, those are the generic circumstances, are accordingly irrelevant to the question.
Can I just understand where this point is leading to? Whether the 4 sample claimants were special or the same as everyone else, under the GLO, everybody was obliged to pay their proportion of it and no more. What is the conclusion that you propose to draw from this, simply so that I can see the direction of the argument?
The end point of this submission is that for the purposes of travellers' contractual obligation to pay for defence costs, that was limited to so far as the uninsured cases are concerned. The costs were limited to the defence of the issue that was truly generic, truly indivisible. The reality is, in fact, that it was in the insured cases, travellers was liable, of course, to pay for all the defence costs, whether individual or generic. That included the costs of defending the indivisible generic issue, which, in my submission, very clearly, it was what I call the Russian roulette argument, the issue that is the same in each case. It included that issue, and that's the indivisible issue that arose. When you look at the uninsured cases, on that generic issue, they were entitled, the Transform was entitled to take the incidental benefit on that issue. So when it comes to that true generic issue, Transform didn't have to pay anything or contribute to anything. But the additional issues that arose in each case that were individual and severable from that, which includes the promises made, the warnings given, and in particular proving the quality of the implants, those are severable issues. So when you look at a case like the Worried Well case, although by the time she came to trial, her implants had been removed.
Mr. Preston, you really have to take more care This lady is your client.
So the worried well claimant, but when she went to trial, the issues in her case would have included the true generic issue, the Russian roulette point of law, and consideration of the particular evidence in her case. So in the case management orders, there was disclosure in each of the 4 cases. There were witness statements as to who said what and to whom on the individual facts of each case. There were directions for expert evidence. And because of the position the defendant was taking about the examination of intrinsic properties, explants were examined by experts in those individual cases where explants were available. And all of that was in fact funded by Travellers. And on all of those issues, Travellers bracketed all of the preliminary issues together in all 4 cases and say, well, that's the common issue, we had to pay for the defence of that. That, in my submission, is the error that was made.
Can we just come back, though, to the order and just to the premise on which all of this is built, that they were only sample cases, only common issues in the what you're calling Russian roulette argument. Doesn't read that way in the order at 461, 462, E numbering, 91 in paper numbering. Why would there be sample cases at all on that basis? The issues were, well, you get my point, I think.
It was obviously considered that the sample cases were going to be of considerable value in resolving the other 459. And on that basis, everybody had to pay their share and was liable for their share under the GLO. Why do you submit that this point, assuming it to be correct, leads to your destination?
Well, just to go back and answer the first part of the observation, the reason for selecting sample cases and the reason why those costs are to be shared across the group was because they achieved 2 purposes. One is that they enabled the court to resolve the true generic issue, the true common issue. And the other is that insofar as they involved individual issues specific to those claims, those would be matters that would be of assistance to the other parties to the other claims, because you've got a resolution on a sample group of 4, and some may succeed, some may fail on their individual facts, but it enables the remaining litigants in the litigation to take into account that decision and would expect then to resolve the issues in those cases. So they fulfill 2 functions, and that, in my submission, is why the definition of common costs, which my learned friend started with, is as it is in the CPR, which I'll go to next, in that common costs includes both the costs of the true common issue in the New Zealand products sense and any individual issues arising in a test case. All of those costs of the test cases, including costs of individual issues, are bracketed together as common costs and divided. And that is precisely because litigants don't simply, there's a pure legal interest in the outcome of the resolution of the true generic issue, but there's also a forensic interest in the outcome of the resolution of individual issues because it enables other parties to take stock.
If the uninsured claimants incurred costs on issues that were unrelated to the particular position of the 4 sample claimants, that surely militates against the suggestion that the insurer of the insured claims should have to pay for them.
Indeed, my lord, and that is exactly my submission, that Travellers' contractual obligation was limited to the defence of the defence costs in the insured cases. And insofar as one can say there's an incidental benefit and therefore it covers uninsured cases, it's limited to the true generic issue. There was no contractual obligation for Travellers to pay for the defence of individual issues arising in uninsured cases.
But the order makes them do so far as
But
those costs have been incurred.
My Lord, the cost-sharing order deals with the claimant's costs, and the claimant's costs are spread severally across the claimant cohort. There was no cost-sharing order so far as the defence costs are concerned. So
It applies to liability and entitlement, doesn't it?
it's the claimant's liability and entitlement, yes. And just to dip into where that is in the CPR, that's at the other authorities bundle at tab 44, MS page 1802. So at 46.6.2, in this rule, individual costs means costs incurred in relation to an individual claim register. Common cost means, one, costs incurred in relation to the GLO issues, and then two, individual costs incurred in a claim while it is proceeding as a test claim. So on the claimant side, you have several sharing of all of those costs, because it's not just the generic issue, but it's also it has a forensic purpose in resolving a sample group on individual cases. And so where my learned friend started this morning was to say, well, because of the IEGL New Zealand products cases, which say we have to pay for the costs of defencing a common issue, he points to the GLO, he points to the cost-sharing order and says, well, there you are, these are common costs, therefore common issues in the case management sense, therefore we had to fund the defence of all 4 sample cases on all issues. That, in my respectful submission, is simply wrong. The costs of defending the 2 uninsured sample cases on individual issues were nothing to do with travellers. And that is important because it sets this problem has a ripple effect when one then looks at how the joint retainer, which was set up to deal with defending...
Is your submission going to be that because travellers unnecessarily funded some parts of the uninsured individual costs, therefore they assumed an obligation to pay everything? Is that going to be the point?
Not that alone, my lord, no. But it's the starting point.
All right, but that's there may be other factors as well, but you're going to say that that is a factor which requires them to be made to pay the lot.
Well, I put it in this way. That is one illustration of them overstepping the mark in funding the defence of issues that they did not need to fund, and therefore, and more importantly, having joint control with Transform in defending each of the 4 sample cases on all issues when they shouldn't have done. That would involve just deciding who the experts are going to be, deciding what tactical points to make in the defence, and so on. That is exercising joint control. May only be 2 cases, but it's 2 out of 4. The litigation was concentrated on 4 sample cases. So half of the sample cases, the Transform is having joint control with travellers in defending those cases on all issues. But as it happens, those were not the particular facts found by the judge related to other aspects of the use of that joint.
I was going to ask you that as the next question. Is it your submission that this was part of the judge's grounds for deciding this point in your favour?
My lord, what she found was that the insurer were involved in the defence of uninsured cases, and it shouldn't have been.
She made 2 findings of overstepping the mark, didn't she? One was concerned with the drop hands settlement, and the other was concerned with disclosure.
Lord, yes, there were three broad topics, but 2 closely related. The admission, the settlement offers, they're closely related, and the disclosure of insurance. So I was going to come to that next.
But not this point. I mean, she doesn't rely on the fact that travel have overstepped the mark by funding the whole of the of Transform's costs of defending the 4 test cases?
My Lord, no.
At the stage when those cases were test cases within the GLO. They might have a life after that stage, for example, on quantum.
No, that's correct. The reason for me sketching this out is because it illustrates the mistake that was made in seeing this as a trial of a single claim or a single issue, seeing it as all parts of one joint claim. So a joint retainer was set up to deal with the defence, not just of 2 of the 4 cases, but all 4 of the cases. And it was that joint retainer that was in play when one later considers, should we admit liability? Should we settle? Should there be a settlement of uninsured cases? Should we tell the claimants that these cases are uninsured? On those issues, which I will come to next, they were all dealt with within the scope of that joint retainer that was set up to deal with what they just call liability in general. And the mistake that was made was in conceptualising this as if it's one case, one claim, with mixed elements. So that's the context of it.
Well, thank you, Mr. President. I think we'll adjourn now and resume at 2 o'clock.